Good day, Crime Talk aficionados. Did Karen Reed's attorneys do something egregious? The judge seems to think so. Richard Allen denied again by Judge Francis C. Gull. Should the indictment against New York Mayor Adams be dismissed? Legislator's immunity, a good thing or bad? A story of the cool mom who gets what she deserves. People who have no impulse control, well, they probably belong in prison, and they'll probably wind up there eventually. You should not bite the hand that feeds you. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And you can check us out on any of your favorite podcasting apps. Now, also, go to crimetalksearch.com, sign up for that background subscription service today. When you do, you can do as many background searches as you desire. And you want to do background searches, ladies and gentlemen. You want to do them on people that are coming into your life, like a story we're going to bring you today. Should you check out the person that's going to be babysitting your kids? I would say so. It's worth its weight in gold. So go to crimetalksearch.com, sign up for that background subscription service today. When you do, you can literally have that report emailed to you while you wait. The report is literally prepared while you wait, and then you can use it, and you can even get updates as new information is updated because they're constantly searching for more information. Go to crimetalksearch.com. You're going to be happy you did. All right, ladies and gentlemen, it is a Tuesday, February 18th already. That's right. It's Tuesday, which means we're going to go live tonight, 6 p.m. Mountain Time. We didn't do it last week because I had to be, somewhere else for court the following day, and I had to head out early, so it didn't quite work out. But we are going to have a lot to talk about. Well, for example, the Karen Reed case. We'll talk about it now, but we'll also talk about it tonight at 6 p.m. I think somebody's in trouble. That's right. Did the attorneys for Karen Reed do something egregious, outrageous, or do I say cause the judge grave concern? Do I even say possibly use the E word? That's right. Involving ethics? Well, the Superior Court Judge, Beverly Cannon, said Tuesday that she has grave concerns over new information shared by the district attorney that may have profound effect on the future of Karen Reed's murder case. And I don't think she's going to be dismissing it. Anyway, Judge Cannon made the surprise announcement after calling for an unplanned recess in a pretrial motion hearing, which abruptly stopped, sending the defense and the prosecutors home for the day. Well, the Commonwealth provided the court with information that causes her grave concern, she said, and the implication of that information may have profound effects on the defense and defense counsel. So what could we be talking about? Well, the judge said, for that reason, I'm going to suspend today so that we can meet again and address these issues. All affected will be appropriately prepared. So Judge Cannon's call for the recess came immediately after the special prosecutor, Hank Brennan. And what did I tell you about this guy? I'm telling you, he's good. They brought him in just to prosecute Karen Reed, and he's good. I've told you that. Anyway, so Special Prosecutor Hank Brennan said in open court that Reed's defense team communicated with ARCA. Those were the accident reconstruction experts originally hired by the federal government about their testimony before Reed's first trial. Well, you say, what's the big deal? Well, the feds originally hired them. And when it came to trial, the defense made it sound as though this ARCA group had been hired by the feds, and we're just here to tell the truth. We've got no dog in this fight whatsoever. Well, it turned out that the defense attorneys were emailing question and answers back and forth. Oh, and by the way, the defense paid the bill of $23,000 to ARCA. Not exactly what was represented in court. And oh, by the way, when you have experts that are retained by the defense, there's certain things that you have to do. You have to turn over their reports. You have to disclose the fact that they are a defense witness. So where do we go from here? So anyway, the special counsel, Brennan, read from what appeared to be emails between the defense and ARCA and referred to the $23,000 bill that he says ARCA sent to the defense. Now, Brennan called it unfair, imbalanced, and hidden in open court. And Brennan recently filed a motion to block the defense's ARCA witness from testifying in Reed's retrial. And in his motion, Mr. Brennan said both Dr. Wolf and Dr. Rentschler admittedly did not review all pertinent and relevant evidence that exists in this case. And Dr. Daniel Wolf, an accident reconstruction specialist, and Dr. Andrew Reichler, a biomechanical engineer specialist, both testified on behalf of Ms. Reed back in June of 2024. So Tuesday's pre-trial hearing marked the first time since the Supreme Judicial Court of Massachusetts denied Reed's bid to get 2 of the 3 criminal charges she faces in the January 22nd death of her Boston police officer boyfriend dropped. Cannon declared a mistrial back in July of 2024 after finding jurors couldn't reach a unanimous verdict of all 3 charges of a second-degree murder, leaving the scene of a crash as well as manslaughter. Now, Reed is accused of killing her then Boston boyfriend police officer John O'Keefe with her SUV, her Lexus SUV, back on January 29th of 2022, leaving him to die in the snow. Now, the defense has sought to portray Miss Reed as the victim of this entire situation, saying that O'Keefe was actually killed inside the Albert family home and then dragged outside and then left for dead. The retrial was supposed to happen on April 25th. And guess what? Karen Reed gave an interview over the Super Bowl weekend to a local TV affiliate, and she said that she has nothing to hide and that she has been framed for murder. So a little more breaking news in the Karen Reed case is that her defense team has filed for habeas relief in federal court, saying that the Massachusetts Supreme Court got it wrong on the whole double jeopardy argument that they appealed to the Supreme Court on. That was obviously denied, anticipated it would be. Everybody blew it, and that's that. I don't expect any relief from the federal court for Ms. Reed on that issue either. But here are here's the big issue in the Karen Reed case. First, if the defense didn't disclose that these people were paid experts, there's ethical issues that the attorneys are going to have to face. Remember, the lead attorney for Ms. Reed is admitted pro hoc vice, which means he is from a different jurisdiction, California to be exact, and he got permission to practice there with the assistance of local counsel. I don't know how things are done in LA, but apparently in Massachusetts, you got to turn over stuff under Rule 16. How much you're paying people? Are they retained experts? If not, guess what? This could blow up big time for the defense attorneys. One, the judge could say, I'm revoking your pro hoc vice status. Ms. Reed, have your attorneys prepared to go to trial. Two, she could strike the defense witnesses, the experts, although the defense may need them. And then that gets into maybe some due process issues. So I think the biggest thing would be a sanction against the attorney. That's where I think this is headed. The judge is not pleased. You could see the reaction on her face when she came out and said, this is not good. We're going to come back next week. They're coming back a week from today, actually a week from tomorrow, Wednesday. And so she's not happy. The prosecutor laid it out in those emails, read them out loud, the back and forth exchange, right? And then the fact that, look at this video right here where it says that he, the defense, did not pay these people. They're just here as the great fact finders trying to help the truth come out, when in fact, it turns out they were hired guns. It's going to get interesting.
Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
And you don't work for us?
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Next on the docket, Richard Allen denied again by Judge Francis C. Gull. That's right, Judge Gull has denied The recent motions filed by Richard Allen's attorneys seeking to re-examine his conviction last year in the Delphi murder case. Now, in an order dated February 14th, Gull denied the defense verified motion to correct error that was filed back on January 20th, and a second verified motion to strike the state's response filed on February 14th. Now, in a separate order, she also denied the defendant's motion to correct abstract of judgment. Now, Gull's rulings were entered into the record on Tuesday, February 18th, and she denied the defense motions without a hearing. She hasn't had a hearing on anything else. I can't imagine why she'd have a hearing on this one. Anyway, the ruling follows a slew of motions in recent weeks seeking to have Allen's convictions re-examined, with the defense citing his safekeeping order, the timeline of a van key to the case, a purported confession from another man, and a disputed headphone jack evidence as factors. Anyway, as you know, on November 11th, the jury found Richard Allen guilty of murder in the February 2017 deaths of Abby Williams and Libby German near the Monon High Bridge there in Delphi, Indiana. Gull sentenced Mr. Allen to 130 years in prison back on December 20th. Now, the defense's 24-page motion to correct error sought to vacate Allen's conviction or a request for a new trial. The state responded on February 4th with its own filing challenging the defense claims, and the defense said that Ron Logan, who owned the property beneath the Monon High Bridge where the girls were found, confessed to an inmate by the name of Richie Davis years ago while both were in prison. But the state countered that Davis miserably failed a polygraph test when the investigators pushed for more information. Now, normally that would be hearsay, but could also be admissible under a statement against penal interest in the sense that nobody admits to something that would have such grave consequences where they could go to prison. So that's why the defense was trying to get that statement in. Anyway, Davis later claimed he'd spoken to Keegan Klein, a convicted child pornographer, tangentially linked to the Delphi case, who implied he, Logan, and a third individual were involved in the murders. Now, Klein told him the third individual was not Richard Allen, according to Mr. Davis. Now, over the weekend, a letter from Davis claimed he had sent multiple letters to the Carroll County prosecutor, Nick McClelland, about Logan's confession, which had been ignored. Now, Davis wrote that he's afraid the state's convicted an innocent man. Well, the defense filed another salvo seeking to strike the state's response and accusing McClelland of misconduct, even suggesting the prosecutor should be held in criminal contempt for releasing photos of Libby German's iPhone 6 in response to the defense motion. You knew that was coming because remember, the prosecutors made such a big deal about the evidence being disclosed by the defense when somebody who was trusted by the defense surreptitiously took pictures of their war room. Anyway, McClelland maintained Allen's lawyers had the chance to bring up many of their claims, including Davis's information about Logan, during its defense of Allen, but they chose not to, making strategic decisions to do so. Now, even though the trial is over, Allen has been sentenced. Gull still has a handful of motions to rule on. The defense filed a motion seeking to preserve all evidence related to Richie Davis, and various media outlets have also filed motions asking for the public release of certain evidence. I'm sure that will all be denied because Judge Frances C. Gull doesn't like to conduct business, court business, in open court. She likes to do it all on paper or in chambers. So I wouldn't expect a whole lot of relief. And, they're going to cite the public good. It's going to be too sensitive. I can hear it all now. Release the information. The public has a right to know. We're all big girls and big boys, and we can handle it. We can even handle pictures that, if we choose to see them, may be disturbing, but we deserve to know. Next, should Mayor Adams have his indictment dismissed? Well, a federal judge in New York has ordered Mayor Eric Adams and the Trump administration's Department of Justice to court over the motion to dismiss the corruption charges filed under the Biden administration against Mayor Adams. So in the order, Tuesday, U.S. District Judge Dale Ho directed both parties to appear before the Lower Manhattan Court on Wednesday at 2 p.m. The judge also ordered Adams to file his consent in writing to the motion to dismiss to the court by 5 p.m. today. Now, Ho said the Department of Justice motion cited how Adams consented in writing, but no such document has been submitted to the court. Now, the DOJ motion cites one judicial opinion regarding the federal rule for dismissal, stating the executive branch remains the absolute judge of whether a prosecution should be initiated and, at first, and presumptively the best judge of whether a pending prosecution should be terminated. And the exercise of its discretion with respect to the termination of pending prosecutions should not be judicially disturbed unless clearly contrary to manifest public interest. Ho, however, cited legal history, noting that a judge has independent obligation once the government has involved the judiciary by obtaining an indictment or a conviction. Additionally, he quoted from a judicial opinion that said a judge must be satisfied that the reason advanced for the proposed dismissal are substantial before approving a dismissal. Now, Adams said 4 of his deputy mayors resigned on Monday in the fallout from the Justice Department's push to end the corruption case against Mayor Adams and ensure his cooperation with President Trump's immigration crackdown. Now, several top prosecutors in Manhattan and Washington, D.C. have also resigned since the Justice Department filed its motion Friday seeking to drop the case. New York Governor Kathy Hochul said that she is weighing removing Adams from office on Monday. Her former boss, ex-New York Governor Andrew Cuomo, is among those rumored to be considering challenging Adams in June's mayoral primary, though he has not officially announced his candidacy. And among the candidates already in the race against the first-term mayor is former city comptroller Scott Stringer and current city comptroller Brad Lander. Now, the Justice Department is investigating alleged insubordination among federal prosecutors there in the Southern District. Now, Mayor Adams has pled not guilty to the charges that while in his prior role as the Brooklyn Borough president, he accepted over $100,000 in illegal campaign contributions and lavish travel perks from a Turkish official and business leader seeking to buy his influence. Now, the Democratic mayor was indicted at the time when he grew critical of President Biden's administration and their response to the worsening immigration crisis there in New York. Now, with President Trump back in office, Adams is cooperating with the border czar Tom Homan, allowing immigration and customs enforcement to once again continue operations at Rikers Island. Now, the upcoming mayoral primary comes at a time with a different judge, Jenny Rivera, of the New York Court of Appeals, considered a law that would allow some 800,000 non-citizens to vote in that race and other city-level contests if implemented. Now, this last week has had a lot of public fights between Bove, the second in command of the Justice Department, and 2 top New York federal prosecutors, interim Manhattan U.S. Attorney Danielle Sassoon and Hagen Scotton, an assistant United States attorney in Manhattan who led the Adams prosecution. Both Sassoon and Scotton have resigned. So this gets interesting, ladies and gentlemen. The question then becomes, who can make a case go away, right? It's funny when the defense always asks for a case to be dismissed. The judge says, I don't have any power. That's up to the prosecution. But when the prosecution says they want to dismiss the case, normally the defendant doesn't object, right? Their case is going away. But every now and then a judge will say, well, I'm not sure this case should be dismissed, like this Judge Ho is doing now. I think Judge Ho has very little judicial precedent in which to go upon. The prosecutors are the ones that bring the case forward. They're the ones to decide whether the case doesn't proceed or not. Now, don't get me wrong. I mean, I get this is all political, but sometimes that's what happens with prosecutors. We see it all the time. People get prosecuted all the time for their people that disagree with people in public office. It's happened. And whether, I guess the mayor has agreed to cooperate, and in exchange for that, there's going to be, this case go away. Is it illegal? I don't think so. I don't think so. It's no different than somebody saying, I'll cooperate with you to get the bad guys off the street if you dismiss my case. Now, personally, I mean, we give Mayor Adams the presumption of innocence, and frankly, it wasn't the most egregious thing, but frankly, I don't know why public officials get any kind of perks from anybody when they're in public office. They shouldn't. They should pay everything their own way. And if they can't, they just shouldn't get it. And I don't care if that's getting upgraded on a flight, as he's this borough president. Shouldn't have to do it. He should have to pay his own way. And that's the problem when you start saying, well, you can accept this, but you can't accept that. I mean, unless it's like a car that comes with the office, like, okay, you get security, you get the car, you get the mansion and at the mayor's office. I get that. Everything else, it's probably corruption. You shouldn't get it. So I'm a little frustrated. I'm not going to lie. I'm torn on this. Do I think the prosecutors can do this, even though the people are objecting to it? Yes. Do I think Adams should probably be prosecuted to send the message? Yes. Do I think they went about it the wrong way? Absolutely. We'll see what the judge decides tomorrow, but somehow I think ultimately the case is going to get dismissed. Next, lawmakers and their immunity. So an Arizona lawmaker has avoided, it's not that big a deal, right? A speeding ticket, because as the member of the state legislature, he has something called legislative immunity. So how did all this, who cares about it, right? Well, the state senator down in Arizona, Jake Hoffman, he's a Republican. He's been in office since 2021, and he got pulled over in January for going 89 miles per hour in a 65 zone, but wasn't ticketed because of his immunity as a legislator. All right, that's the law. The trooper recognized the senator, verified that Mr. Hoffman is in fact a state senator, and that the legislature is currently in session, and he was given a free pass. Now, legislative immunity isn't anything unique and novel. Every state has it. Even the feds have it. But the one in Arizona says legislative immunity is granted to lawmakers based upon Section 6 of the Arizona State Constitution. And members of the legislature shall be privileged from arrest in all cases except treason, a felony, and breaches of the peace, and they shall not be subject to any civil process during the session of the legislature, nor for 15 days next before the commencement of each session. That's the law. Why do they do that? People, if they were in the legislative bodies, they would get held up by frivolous lawsuits. They would get served with papers because they knew where they were going to be. They would get arrested and harassed, so they couldn't make it to the legislature on time, so that they couldn't pass bills. Maybe there couldn't be a quorum for them to proceed. So this was put into place. So the question is it some sort of privilege that needs to be taken away? Anyway, the spokesperson for the senator stated that the senator didn't mention his immunity during the traffic stop. And it was the officer who realized that Hoffman, who he was, and he was a lawmaker, and that's why he wasn't given a ticket. The legislator did say, I don't break the law because I can, because, I'm just trying to get home. And the legislator also told the officer that he pulled him over not to waste his time trying to give him a ticket because of the legislative immunity. Anyway, the legislator later apologized in a social media post, but the video of him appearing to brag about the ability to speed caused a little bit of anger there in the state of Arizona. At one point, a former governor actually tried to take away that legislative immunity, but it failed. Of course it would. Got to have the legislature pass it. Why would they take away their immunity? Anyway, efforts to revive that removal of legislative immunity for traffic violations is once again being considered. We'll have to see where it goes. It's a good thing. We once had a legislator get a ticket for DUI and he tried to get the pass because he was a legislator in session, even though he was driving drunk. Ultimately resigned. That was the honorable thing to do, right? Lawmakers are supposed to do it better and cleaner than everybody else, but they don't always do so. Next on the docket, the fun mom gets what she deserves. I hate fun moms. I don't think that moms, dads are supposed to be fun. They're supposed to be parents, and they're supposed to be teaching people wrong from right. Anyway, a 21-year-old is arrested for stabbing of a juvenile at a party on Saturday night. Now, the Walton County Sheriff's Office received a call for 911 just before 10 p.m. from the victim's friends as they called for help while en route to the hospital. Now, the caller told the deputies their friend had been stabbed while at a party at a residence in Portland Park Road. Deputies met up with the caller and the victim, a guy by the name of Grady Brown Park. Anyway, the Walton County Fire Rescue responded and transported the victim with the stab wounds to the head and the neck. Additional calls came in regarding the incident. Deputies responded to the address, interviewed multiple people as well as interviewed multiple witnesses, and reviewed video evidence. All parties identified John Kincaid, a 21-year-old, as the suspect and said that they saw him stab the victim with a knife multiple times. Kincaid was subsequently charged with aggravated battery and aggravated child abuse, and his bond was set at $5,000. He remains in custody. Well, things get weird is that Kincaid's mother, Crystal Rabin Kincaid, was also arrested following the incident. She faces charges of tampering with evidence after telling witnesses to delete cell phone videos of the incident. She was released on a $15,000 bond. Now, a motive for the stabbing has not been released, and John Kincaid's father, who has the same name as his son, is also in jail because why, you may say? Well, he was driving over to the residence to check things out. Anyway, the police checked his license, found out it was suspended, and he got arrested. You know what I always say? The family that does time together stays together. And seriously, why are parents throwing parties for kids, even 21-year-old kids? Don't do it. There were juveniles there. That is called contributing to delinquency of a minor. It is a felony, ladies and gentlemen. Quit trying to be the cool parents by providing drugs and alcohol to kids. Do not do it. It is a crime. And I get it. It's all fun and games. Oh, we did it when we were... Times have changed. When we were kids, nobody cared. But now somebody gets sick, somebody overdoses, somebody gets in a car and drives, and guess what? Those parents, their lives are over. Don't do it. Don't do it. Next, if you have impulse control issues, you're probably going to prison. Let me introduce you to a Michigan man. He's been arrested after police said he drove 700 miles to set fire to a home in Pennsylvania for a man who had communicated with his ex-girlfriend online. I think that's some impulse control. And if you can't calm down after driving 700 miles, oh man, you've got some anger issues. Anyway, the Ben Salem Police Department said that Harrison Jones of Rockford, Michigan, was arrested for setting fire to a home with 6 people inside. Now, the people inside were hospitalized while their family's 2 dogs, Trey and Jet, didn't escape and they died. Anyway, police said the people inside the home were able to escape thanks to the mom who heard suspicious noises before finding the fire and evacuating her family, adding that some family members even had to jump out of a 2nd-story window to escape the flames. Anyway, the fire rescue and the Ben Salem police detectives began investigating the cause of the fire and determined that it was intentionally set and incendiary in nature, i.e. arson. Officials said the only lead in the case was a grainy image of a black sedan from a neighborhood surveillance camera. There's always that surveillance camera. Anyway, the video captured a vehicle pulling up to the home around 5 a.m. that morning. A suspect is then seen exiting the vehicle, walking towards the back of the home, where police say he stayed for over 10 minutes before he is seen running away from the house and then speeding off. About 30 seconds later, there's an explosion erupting and the house goes up in flames. Now, 2 days after the fire, investigators were able to trace the vehicle back to Mr. Jones, and they obtained an arrest warrant for him back in Michigan. Investigators added that Jones also had burns on him when they arrested him. Apparently, the burns were on his arm. Anyway, the police also confirmed that Mr. Jones is the ex-boyfriend of a woman from Michigan who had been in an online relationship with a male resident in the Ben Salem house since 2023. However, a motive for the fire is still being investigated. Motive still being investigated? Are you kidding me? He wanted to kill somebody. That's what he wanted to do. He drove 730 miles. That's 11 hours to do what he did. And then after starting the fire, turned around and went back home directly. Needless to say, Jones is charged with 6 counts of attempted homicide, arson, and a bunch of sundry of other related offenses. And he is currently waiting extradition back to Pennsylvania. That man needs to go to prison. He's got some anger issues. He's got some impulse control issues. And after 11 hours, if you thought it was still a good idea to drive from Michigan to Pennsylvania to set the house on fire, you just got to go to prison. Now, we'll give you the presumption of innocence. I get that. But if he's convicted, he needs to go to prison. He tried to kill 6 people, ladies and gentlemen. Next, don't bite the hand that feeds you. Police arrested a 22-year-old woman they allege stole clothing, handbags, and other items from homes where she babysat, and then she took the items and put them online for sale. So the Lake Forest Police Department learned about a suspect thief who allegedly stole jewelry, bags, and clothes from residents in Lake Forest and Lake Bluff. Police identified Derisa Chavarria as the suspect and said she reportedly took the items from the homes and posted them on Facebook Marketplace. She was arrested on 2 felony counts in Lake Forest. After the state's attorney's office approved Chavarria's arrest warrant, a Lake Bluff resident contacted the Lake Forest Police Department and said she believed that Chavarria stole at least $10,000 worth of personal belongings from her home when she worked for her as a babysitter. Soon after that, another resident said she was missing about $1,700 worth of jewelry. Police executed a search warrant of Chavarria's home. Guess what? She's now also facing an arrest warrant out of Lake Bluff for theft as well. Both Lake Forest and Lake Bluff police departments urged anyone who hired Miss Chavarria as a babysitter to check their valuables. Needless to say, the police say, hey, we commend victims who come forward to report these thefts, and many people hesitate because victims often feel as though, they feel a little silly. They don't feel it's worth it, thinking that they'll never get their property recovered. This is a classic example of why you need to use CrimeTalkSearch.com to search out the Miss Chavarrias in the world. Get that background report and see if they have something on their record. My guess is Miss Chavarria has something on her record. All right. And next on the docket, this day in legal history. On February 18th, 1851, President Millard Fillmore issued a proclamation condemning the rescue of Shadrach Minkins, an escaped slave who had been seized in Boston under the Fugitive Slave Act, but was then freed by abolitionists. Now, obviously, this was 10 years before the Civil War, but it showed the intense national division over slavery and highlighted the challenges of enforcing the Fugitive Slave Act in the northern states. And on this date, February 18th, 1861, that's right, Jefferson Davis was inaugurated as the Confederate president. That's right. Jefferson Davis was inaugurated as the provisional president of the Confederate States of America in Montgomery, Alabama. And obviously his inauguration then solidified the secessionist movement, leading to the Civil War and subsequent legal battles over states' rights and federal authority. And then on this date in 1972, the California Supreme Court ruled in People v. Anderson that the death penalty was cruel and unusual punishment under the state constitution. That decision temporarily halted executions in California and influenced debate on the capital punishment nationwide. In 1978, the death penalty was approved by referendum by voters in California, and it was reinstated with a 71% approval from the voters. And then in 2019, Governor Gavin Newsom halted all executions. And anyway, California voters have rejected past referendums to abolish the death penalty. So it's the court and the governor that apparently ignore the will of the people in California. California would not have the death penalty if it was not via referendum. Probably would be like that in most states, I dare say. And finally, our dumb criminal of the day. This was sent in to us from Michael. Always appreciate people finding interesting stories. But these two knuckleheads come from Colorado, and then they travel to Louisiana. And what are they trying to do? They're trying to smuggle drugs into a federal prison. Apparently, the Grant Parish Sheriff Office has assisted in arresting them. According to the Grant Parish Sheriff's Office, these two knuckleheads were attempting to smuggle roughly $112,000 worth of tobacco and $89,000 worth of methamphetamine into the federal prison using, wait for it, not a drone, not the old-fashioned way of just throwing it over the fence. No, an air cannon. That's right. You know, the kind that they shoot T-shirts out of, games to make them go far. An air cannon propelled by compressed air to launch the items over a security fence and onto the prison grounds. The cannon has a range of about 350 feet, but guess what? Didn't quite work out so well for them. Jose Francisco Herrera Munoz was arrested along with Angel Gonzalez Gutierrez, both of Greeley, Colorado. Had to be from Colorado. God, we're getting as dumb as Florida. Anyway, they've been arrested for introducing contraband into a penal institution and attempting to distribute methamphetamine. And it also didn't work out for one of them because Mr. Munoz now has an immigration detainer on him, which means that once he gets done serving his prison sentence for introduction of contraband into a federal facility, guess what? Then he's going to get deported. Mr. Munoz, you are a dumb criminal of the day. All right. Thanks for watching, everybody. Please remember to join us live, 6 p.m. Mountain Time. We have a lot to talk about with this Karen Reed development. Did the attorneys do something sleazy and unethical? How is this going to affect the Karen Reed defense? Well, join us tonight at 6 p.m. and let's talk about it. That's all we have for today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.